Imagine a worker who knows the safety rules, yet intentionally bypasses a heavy steel guard to save a few seconds on an adjustment. The machine cycles, and the resulting injury is severe. Despite the fact that the employee made a conscious decision to break protocol, OSHA concludes its investigation by issuing the company a $150,000 fine. This creates a difficult question for the employer. How can a company be held legally and financially responsible for a decision a worker made in secret? OSHA's regulatory framework operates on the premise that most workplace injuries are the result of failures in management oversight rather than random chance. This logic relies on constructive knowledge. If a supervisor is close enough to see a violation, the law treats that proximity as actual knowledge. If a hazard was discoverable through reasonable diligence, the employer legally knew it existed. Under this standard, claiming you weren't aware of a hazard isn't a defense. It's often viewed as evidence of a failed safety system. To challenge this, the employer must move the battle into federal court. They cannot simply wait for the government to fail to prove its case. They must go on the offensive. This requires pleading an affirmative defense, which reassigns the burden of proof. The company must now present evidence to demonstrate its own compliance. The Occupational Safety and Health Review Commission evaluates these claims using a strict four-part test. To win, an employer must satisfy every one of these four pillars. The first pillar requires specific work rules. Broad slogans are insufficient. Rules must explicitly address the exact cited hazard. The second pillar is communication. A manual is useless unless the company proves the employee was specifically trained on it before the accident. These two pillars make up what is often called a paper program. While necessary, a safety manual will not hold up in court if it lacks the operational enforcement found in the final two pillars. The third pillar requires management to actively discover violations. On a complex job site, the law expects the employer to proactively hunt for noncompliance. If a company only discovers hazards after an accident occurs, a judge may view that as a failure of reasonable diligence. The fourth, and often most difficult pillar, is effective enforcement. The company must show that when employees break the rules, they are consistently disciplined. During an audit, the evidence that often defeats a company's defense is a pristine employee disciplinary file. If there is no record of safety write-ups or warnings prior to the accident, the court may conclude that the company's safety rules were not actually enforced. This is especially true in cases of supervisor misconduct. If a foreman is the one breaking the rule, it suggests the company's safety culture is compromised at the leadership level. Ultimately, a safety program is judged not by its training budget, but by management's willingness to discipline its employees, even high-performing ones, for safety violations. Building a legal shield requires a consistent workflow. You perform spot checks, identify violations, intervene immediately, and document the encounter. In the eyes of a compliance auditor, if an action isn't written down, it effectively never happened. Verbal warnings provide very little protection in a legal setting. A paper trail of progressive discipline, from written reprimands to suspensions, is necessary to sustain a defense. This leads to a counterintuitive reality. A documented history of minor safety infractions and subsequent discipline actually protects a company. It proves that the safety system is functioning as intended. Without that paper trail, constructive knowledge remains a major liability, allowing regulators to place the responsibility solely on the employer. Under federal law, a worker's choice is only considered unpreventable if the company can prove it did everything possible to stop it. The strength of your defense rests on whether you are willing to enforce the rules before an accident happens.